Good day, everyone, and welcome back to Persons and Family Relations. Today, we will start discussing Article 14 of the new Civil Code, which provides that penal laws and laws of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Ladies and gentlemen, here in the Philippines, we adhere to the doctrine in criminal law known as the theory of territoriality. Alright? Wherein any offense committed within our country offends the state. Therefore, any person, whether citizen or alien, can be punished for committing a crime here. Thus, the technical term generality came into being. It means that even aliens, no? When we say aliens, mga foreigners ha, not flying aliens or something like that, male or female, come under our territorial jurisdiction. This is because aliens owe some allegiance of sort to our territory, even if it be temporary. When we say living, mailhana dire nagpuyo sa Pilipinas. When you say sojourning, temporary lang ang stay here in the Philippines. Okay? Example of this is if, say, Joven, an American citizen, okay, Amerikano si Joven in this case, and he comes to Colon, and then mulabang si Joven sa Colon, unya, nag-jaywalking siya. And then Joven will say, oh, you cannot arrest me for jaywalking, Joe, because I am an American citizen. Joven cannot do that because here in our country, we adhere to the generality principle, meaning penal laws and those of public security and safety shall be obligatory upon Joven, even if Joven is an alien in this particular instance. Okay? I hope that's clear. Another thing is, let's say, Joven is prosecuted for, say, rape. This is just an example, Joven, ha? And Joven would say, I cannot be prosecuted for offenses in the Philippines because I am an Americano. Joven cannot say that because as earlier discussed, penal laws are obligatory upon Joven bisan pag Amerikano si Joven. That is what is meant by the generality principle. Penal laws as well as of public security and safety shall be obligatory upon everyone, whether living or sojourning in the Philippine territory. But of course, as earlier mentioned, no, every general rule, ang atong general rule is laws are binding to everyone, 'di ba? Whether living or sojourning in the Philippine territory, that's under the generality principle. But there is an exception even if that particular person is in our territory, dili siya bound to answer for an offense which he or she may commit here in the country. The exception ani is kaning principles of public international law and treaty stipulations. What is this theory or principle of public international law? This says that immunities granted to diplomatic officials and visiting heads of states, provided the latter do not travel incognito, they are immune from suit, okay, or from criminal prosecutions. Remember that if they travel incognito, when you say incognito, they did not inform our country that they are here and they are heads of states or members of diplomatic, or if they are diplomatic officials, right? But with the knowledge of our government officials, if they travel incognito, heads of states are entitled to immunity. If the incognito travel is without the knowledge or permission of the country, the diplomatic immunity cannot be insisted upon and the heads of states traveling may be arrested. However, once they reveal their identity, of course, the immunity is now given. Example, no, the President of the United States, si Donald Trump, muari siya diri sa Pilipinas, and if he commits a crime, he is immune from criminal prosecution because under Article 14, no, Penal laws shall be obligatory upon all who live or sojourn in the Philippine territory, but subject, of course, to the principles of public international law. And the principles of public international law would provide that heads of states are actually immune from criminal prosecution. That's the first exception, ladies and gentlemen, under Article 14. Now, another exception is the treaty stipulation. An example of this treaty, stipulation is a treaty entered into between the Philippines and the United States. Kinumdo mo atong military basis agreement. I think this has already been abolished. The military basis agreement, the RPUS military basis agreement, entered into between the Philippines and the United States, wherein some provisions would exempt certain members of the armed forces of the United States from the jurisdiction of our courts. If, let's say, kanisiya is still effective, ang example ani would be this. Let's say a member of the American military would come here in the Philippines and then would commit a crime, let's say, mang-rape siya. And then, under the RPUS military basis agreement, there's a provision there na if any of the member of the military of the United States would commit a crime here in the Philippines, they shall not be subject to the jurisdiction of the Philippines, but subject to the jurisdiction of the United States of America. Let's say that's one of the stipulations in that particular treaty, the RPUS military basis agreement. The Philippines, in this case, cannot now take jurisdiction over that particular member of the military because of this particular treaty stipulation. Okay? Mao lang na siya ang exception in this particular article, Article 14 of the new Civil Code. Mao na siya ang gi-mention here. Alright? Remember that those exceptions are just the exceptions mentioned in your Article 14 of the new Civil Code. I want to remind everyone na when you're listening to this recording, you must have with you at least your codal provisions or your book in persons and family relations in order for you to have a better understanding of what we're talking about here. Okay? Some of the provisions would later on ensue or would later on be discussed by your professor in your Criminal Law 1, okay? There are a lot of exceptions provided for in your criminal law with respect to the territoriality as well as with respect to the generality principle. So for now, that's just it for Article 14, and we now move to Article 15. Article 15 provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Meaning, whenever or wherever you are, your status will always be governed by Philippine laws. Okay? What do we mean when we say status? When we say status, the status of a person in civil law includes the personal qualities and relations, more or less permanent in nature and not ordinarily terminable at his own will, such as his being married or not, or his being legitimate or illegitimate. Kung minyo ka diri sa Pilipinas, when you go abroad, you are still married. Okay? Kung lalaki ka diri sa Pilipinas, when you go abroad, you are still a lalaki. Okay? You have to remember that. Kung single ka diri, ay, abot ni mo dito, sure ko single yapon ka. Okay? Bouvier's Law Dictionary defines status as the sum total of a person's rights, duties, and capacities. Sanchez-Roman considers civil status the distinct consideration of a person before the civil law. Article 15, ladies and gentlemen, is what we call the nationality principle. Okay? Remember that Article 15 refers to the family rights and duties, including the parental authority, the marital authority, support, etc., etc. It also refers to status, the condition, and the legal capacity of a person. Okay? Guys, kanidi ang Article 15 is actually a rule of private international law or conflicts of law. Okay? Later on in your study of law, you will encounter a subject entitled or named conflicts of law. There, you will study the conflicting laws between our domestic laws and international laws. And one of the laws that you will be studying in that subject is Article 15 of the new Civil Code. Example is this. Let's say Joven and Mary are married. And then their marriage here in the country is considered void. Let's say void siya because si Mary was a minor when they got married. Example lang. And then Joseph and Jovelyn, another couple, are also married but also void gihapon because let's say in this case si Joseph kay minor when they got married, okay? And then Joven and Jovelyn met abroad. Niadto sila US because they were working, okay? Si Joven came from a void marriage. Jovelyn also came from a void marriage, okay? So Joven and Jovelyn went abroad in the United States and then they got married there. The question is this: is the marriage between Joven and Jovelyn valid? Let's just say that in the United States, their marriage was actually valid, okay? And under the principle of Lex Lucae Celebrationes, when a contract is valid, were celebrated, it will also be considered valid here in the Philippines. Question: will that particular principle, Lex Lucae Celebrationes, be made applicable here in the country? Answer is no. The marriage between Joven and Jovelyn is void because actually later in your study in persons, you will learn that there are essential and formal requisites of marriage. Og isa aning mga requisites of marriage is the legal capacity of the contracting parties. And sa legal capacity sa contracting parties, apil ani nga dapat walay legal impediment ang parties. Unsa man ang legal impediment? Pasabot ana nga dapat dili siya minyo when he or she contracts a marriage, okay? And then you might say, "Yeah, attorney, the marriage between Joven and Mary are actually void man kaha. And then also with Joseph and Jovelyn, void man na siya. So dito valid ilang kaminyoon, pwede ra gyud sila magremarry." It doesn't matter, ladies and gentlemen, ha? Kay ingon ang family code, particularly in Article 40, nga the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Before na sila magpakasal abroad, before na sila makapakasal og subsequent marriage, no, kailangan i-declare una sa court by final judgment that their previous or their prior marriage were actually void. Okay? So dapat si Joven ning file sa siya og kaso for the declaration of nullity of his marriage with Marie, and Jovelyn also should have done the same. Dili pwede nga sila ray mo ingon nga void among marriage. Dili valid among marriage. So pwede ra may magpakasal sa abroad kay pwede ra didto sa US nga magpakasal basta void ilang marriage diri sa Pilipinas. That cannot be done, ladies and gentlemen. Because the Supreme Court said in Mercado versus Tan nga it is not for the parties kuno to determine the validity of their marriage, but it is for the court of competent jurisdiction to declare the marriage void. Otherwise, it would be so easy for them to be scot-free from liability. Okay? You have to remember this. Bisan pag naa sila sa laing nasod, mubalik gihapon ta sa Article 15 nga nag-ingon, laws relating to family rights, duties, legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Kay minyo man sila diri sa Pilipinas, and even if the said marriage is void, nag-ingon man ang ato ang Philippine law nga kung void imong marriage, ipa-declare sa nimo nga void before ka makapakasal. Dapat sundo na nila because under the nationality principle, binding na nga balaod bisan pag naa sila didto sa abroad. Okay? The same is true between minors. Let's say Joven and Marie got married in the United States of America when they were still 16 years of age. And then in America, let's say valid ang kaminyoon, bahalag 16 years old mo. Ikabot diri sa Pilipinas, pangutana, will that marriage between Joven and Marie be considered valid? The answer is no. Because legal capacity of persons, in order for them to get married, the contracting parties must be at least 18 years of age. Balik gihapon ka sa Article 15 nga laws relating to the legal capacity of persons are binding upon citizens of the Philippines even though living abroad. You have to remember that, guys. Okay? That's the nationality principle. We now move on to Article 16 of the new Civil Code. It states that real property as well as personal property is subject to the law of the country where it is situated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law, national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein the said property may be found. Okay? This is another conflicts rule on property. This is the so-called Rex Rei Sete. Tanawan ng first paragraph, guys. Balik ko na to. Real property as well as personal property is subject to the law of the country where it is situated. This is the so-called doctrine of Lex Rei Sete. Ang pasabot lang ani nga properties, whether real or personal, are as a rule governed by the doctrine of Lex Rei Sete. Unsa din ning Lex Rei Sete? This means that the law of the place where the property is situated should govern the property relations of the same. You have to remember that it is inevitable that the rule should be thus for real property, for after all, real property is attached to the soil or to the land, and a contrary rule may render a judgment on the land ineffective or incapable of enforcement. You might ask, unsa maning real property? Unsa maning personal property? When we talk about real property, these are immovables. Property that cannot be transferred from one place to another, such as land, building. Kana, mga real property na siya. And when we talk about personal properties, these are movables. These are properties which can be transferred from one place to another. A car, a table, a chair, sinina nimo. These are personal properties, okay? Upon the other hand, the rule enunciated under the new Civil Code for personal property actually changes the old rule. Because in the past, under the old Civil Code, no, ang kaning personal property will follow the owner. So, sa una, personal property follows the national or the domiciliary law of the owner under the doctrine of mobilia sequentur personam. However, under the new Civil Code, there has been a great increase in the amount and variety of personal property not immediately connected with the person of the owner. And it was deemed advisable by the Congress of the Philippines to adopt the doctrine of Lex Rei Sete, also to movable. So now, there is no more any distinction as to what principle or doctrine should govern with respect to both real and personal properties. Basta maghisgot kag real property as well as personal property, it shall be governed or it shall be subject to the law of the country where it is found. Kung asa na nimo makitaan, the law that should govern over that particular property should be the place or the law of the place where it is situated. Okay? Now, let's see if the shares of stocks or what law should govern with respect to the shares of stock. Remember that a foreigner can actually own a share of stock here in the Philippines, right? So, shares of stock of a foreigner, even if personal property, can be taxed in the Philippines, so long as the property is located in this country. Also, you have to remember that bank deposits in the Philippines, even if they belong to a foreigner, may also be a subject of attachment proceedings because naaman diri, and the doctrine or the law that should govern should be by virtue of the doctrine of lex re sete. Taxes may also be imposed on dividends from shares in a gas corporation situated in the Philippines, even if the stockholders do not reside here in the country. Okay, we have to remember that principle, lex re sete, law of the place where the property is situated. Now, lex re sete or the lex situs rule has an exception. And the exception is also found in the same article, in Article 16. That is found in the second paragraph. Niingon ang second paragraph nga, however, intestate and testamentary succession, both with respect to the order of succession, to the amount of successional rights, and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration. And ningon pagyud ang second paragraph in Article 16, whatever may be the nature of the property and regardless of the country where the said property may be found. Thus, the following matters are governed not by lex situs but by the national law of the deceased as follows. Una, the order of succession. Ikaduha, the amount of successional rights. When we say amount of successional rights, this refers to the amount of property that each heir is legally entitled to inherit from the estate available for distribution. Next, intrinsic validity of the provisions of the will. Example, whether there be a disinheritance or whether the disinheritance has been properly made or not, or whether the testamentary disposition can be given effect or not. And then the last one is the capacity to succeed. Okay? Example ani is a Filipino couple. A Filipino couple is are vacationing abroad. And then the husband, in this case, instituted the wife as his sole heir. Okay? Niingon ang bana, pinangga kay nako akong asawa, I will institute my wife to be my sole heir. But here in the Philippines, both the wife and the husband actually left 10 children. 10 children na po ka mga anak, okay? Let's say if the husband would die in the US, and if it is probated there, if the will is probated there, is the will valid? The question now is the will executed by the husband in the United States of America, instituting as his sole heir the wife, be considered valid? The answer is, of course, no. Because the second paragraph of Article 16 provides that intestate and testamentary succession, both with respect to the order of succession, to the amount of successional rights, and intrinsic validity of testamentary provision, shall be regulated by the national law of the person whose succession is under consideration. Kinsa man ang person whose succession is under consideration here? It is the husband who executed the will outside of the country. Okay? The husband who executed the will in the United States of America. Article 16, paragraph 2 provides that ang provisions in that particular will shall be regulated by his national law. What is his national law? Philippine law. And according to Philippine law, ang person has the so-called compulsory heirs. Unya, kung naa siya ay compulsory heirs, ang compulsory heirs will be entitled to the so-called legitim. And this legitim is reserved by law and must not be impaired. Meaning, kung manghatag ang nagbuhat og will, dapat dili ma-impair ang legitim sa iyahang mga compulsory heirs. Kinsa may mga compulsory heirs? Who are these compulsory heirs? These are the children. The spouse is just one of the compulsory heirs. So in this case, klaro kaayo nga the legitim of the children of the husband and the wife was actually impaired, and thus that will not be considered valid. I hope that's clear, huh? And now another principle that you will encounter in this particular article is the Renvo Doctrine. Okay? The Renvo Doctrine. This Renvo literally means a referring back. Okay? It literally means a referring back. The problem arises when there is doubt as to whether a reference in our law or to a foreign law should be made. Ang example ani is, let's say there is an American and then he is domiciled in this country, and then when he was here, he dies. And if he dies, the question would be what law should govern his succession. So, under the Renvo Doctrine, you will refer the issue unto the national law of the decedent. In this case, the alien. Diba? So, adto rito, tanaw ni mo, unsa may iyang national law. It's an American law. When you go to America, the America will now say, oh, you refer this back to the Philippines. Because under our law, kung asa siya na domicile, it should be the law that should govern his successional rights. Perhaps the very first case where our Supreme Court has been able to expand at length on what we ought to do when confronted by the Renvo problem is the case entitled In the Matter of Testate Estate of the Deceased Edward Christensen versus Helen Christensen Garcia. Okay? Ang salient facts of this case are as follows. Edward Christensen, though born in New York, migrated to California, where he resided and consequently was considered a California citizen for a period of 9 years. Okay? Now, in 1913, he came to the Philippines, where he became a domiciliary till the time of his death. However, during the entire period of his residence in this country, he had always considered himself a citizen of California. And in his will executed on March 5, 1951, he instituted an acknowledged natural daughter named Maria Lucy Christensen as his only heir. But he left a legacy of a sum of money in favor of Helen Garcia. Si Helen was considered to be an acknowledged natural daughter of Edward. So, ang counsel for Helen claims that under Article 16, Paragraph 2 of the Civil Code, California law should be applied because he is a national of California. And that under California law, the matter is referred back to the law of the domicile. That therefore the Philippine law is ultimately applicable, and that finally the share of Helen must be increased in view of the successional rights of illegitimate children under Philippine law. Upon the other hand, the counsel for Maria Lucy contends that inasmuch as it is clear that under Article 16, Paragraph 2 of our Civil Code, the national law of the deceased must apply, our courts must immediately apply the internal law of California on the matter, that under California law, there are no compulsory heirs, and consequently, a testator could dispose of any property possessed by him in absolute dominion, and that finally, according to Maria Lucy, the illegitimate children not being entitled to anything under California law, the will of the deceased giving the bulk of the property to Maria Lucy must remain undisturbed. Kaya ang argument manggod rin ni Helen, since I am an acknowledged illegitimate child, I am entitled to my legitim. Because as earlier stated, no, ang compulsory heir would consist of the children, whether legitimate or illegitimate. Basta acknowledge lang ang mga illegitimate, entitled siya to a legitim, which is one half of the share of a legitimate child. Okay? So, ang ingon rin ni Helen, since I am an acknowledged natural child, I am an acknowledged illegitimate child of Edward, and under California law, the law that should govern should be Philippine law because this is being referred back here to our country, I am entitled to more than just the sum of 3,000 pesos nga legacy, because 3,000 na may gihatag sa iya nga legacy in this case. Si Maria Lucy on one hand would argue, since Edward in this case is a California citizen, the law that should govern is the internal law of the California. So you apply the California law, and in California law wala man sila gitawag dito nga compulsory heirs. So dili bound si Edward over that particular argument of Helen nga entitled siya to a legitim. So this issue reached the Supreme Court. And the Supreme Court decided to grant more successional rights to Helen. And it said in effect that there are two rules in California on the matter. First, according to the Supreme Court, the internal law which should apply to Californians domiciled in California, mo ng internal law. Gi-explain sa Supreme Court, the internal law, Maria Lucy, should apply only to Californians who is domiciled in California. And the conflicts rule, which should apply to Californians domiciled outside of the California. So, duha siya, ang internal o ang conflicts rule. Okay? The California conflicts rule found that if there is no law to the contrary in the place where personal property is situated, it is deemed to follow the person of its owner and is governed by the law of his domicile. Edward being domiciled outside California, according to the Supreme Court, the law of his domicile, the Philippines, ought to be followed. Were we to throw back the matter to California, the problem would be tossed back and forth between the states concerned, resulting in international football. Mo na giingon sa Supreme Court. So, the case was remanded to the trial court for further proceedings in order for the trial court to determine the successional rights of the parties under Philippine laws. So that, ladies and gentlemen, is the case of in the matter of the estate of deceased Edward Christensen versus Helen Christensen Garcia. Now on to Article 17. Article 17 provides that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines or in a foreign country, the solemnities established by the Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in foreign country. The first paragraph of this article lays down the rule of lex luce celebrationes insofar as extrinsic validity or the forms and solemnities is concerned. Thus, a contract entered into by a Filipino in Japan will be governed by Japanese laws insofar as the forms and solemnities of the contract are concerned. However, formalities of the acquisition, encumbering, and alienation of property shall be governed not by lex luce celebrationes but by lex re site. Example, in Japan, a Filipino sold to a Filipino a parcel of land located in the Philippines. The law that should govern the formalities of the sale should be the law of the Philippines because the law is or because the land is located here in the Philippines. This is an exception to the principle of lex luce celebrationes. Okay? Now, also remember the rule of exterritoriality, wherein even if the act can be done abroad, still if executed before Philippine diplomatic and consular officials, the solemnities of Philippine laws shall be observed. The theory is that the act is being done within an extension of Philippine territory. And this is the so-called principle of exterritoriality. I'm sure you've also discussed this in your criminal law. Now, the third paragraph, ladies and gentlemen, gives one exception to the rule that a foreign law, contract, or judgment can be given effect. The reason is that public policy in the Philippines prohibits the same. Example of an act that is prohibited here in the country, even if abroad it is allowed, is a contract for the sale of human flesh or prostitution. Even if the said contract is valid where it is made, it cannot be given effect here in the Philippines because it is against our public policy. Okay? Also, an absolute divorce granted to Filipinos abroad. Even if it is valid where given, it cannot be recognized here in the Philippines because under Article 50 relating to family rights and duties or the status, condition, and legal capacity are binding upon citizens of the Philippines even though living abroad, and under our family code, absolute divorce is not allowed, okay? Except, of course, insofar as our Mohammedan Filipinos are concerned. Because Muslims can actually file for an absolute divorce, okay? Now, the last article that we shall tackle today is Article 18. In matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. Remember that in case of conflict with the Code of Commerce or special laws, the Civil Code shall only be suppletory, except if otherwise provided for under the Civil Code. In general, therefore, in case of conflict, the special law prevails over the Civil Code, which is general in nature. So guys, remember the important principles in Articles 14 to 18. In Article 14, remember the principle or theory of generality. In Article 15, you remember the nationality principle. Article 16, you remember the principle or the doctrine of lex re sete. Okay? And of course, the exception to the doctrine of lex re sete, which is also the nationality principle. In Article 17, you also remember therein the principle of lex luce celebrationes. Alright? And of course, the rule of exterritoriality. Article 18, the conflict between the Civil Code and other special code. Next meeting, we will discuss the provisions found in Chapter 2, particularly in human relations. So that, ladies and gentlemen, concludes our discussion on Chapter 1, the effect and application of laws. I hope you learned something from it. If you have questions, clarifications, or any concerns, please comment down below and send me a private message so that the same will be addressed as soon as possible. Thank you very much. Amping.